and welcome to the Brainstorm Room's very first webinar. The Brainstorm Room aims to be New Zealand's most comprehensive help and advice website for small, medium and family-owned Kiwi businesses. Hi, I'm Jamie Tulloch, co-founder of the Brainstorm Room and managing director of E3 Business Accountants. We're the engine room behind the Brainstorm Room. So firstly, thank you for registering for this very important webinar. We had more registrations than the webinar platform could handle, so we created a second webinar, which is coming up this Thursday morning. Unfortunately, we had to bump many registrations to the Thursday webinar. If you did not get an email that your seat had been moved to Thursday, then you're good to stay with us this morning. So let's talk briefly about how this webinar will work. As a webinar audience, you have two options. You can quietly sit there and be a passive observer and treat it like watching TV, or you can get actively engaged and ask questions. So to ask a question, you just scroll down a little and you'll see an area to type in your question. Now, because of the large number watching this webinar, we expect a lot of questions. Andrew will do his best to answer them all during and at the end of the webinar. What he doesn't get to answer today, he will do his best to follow up by email over the next few days. And to go one step further, Andrew has kindly offered to provide a free assessment of your personal trust situation. We have developed an online form for anyone wanting a free assessment, and it looks a little bit like this. After the webinar, we will email you a link that takes you to the online assessment form. So Andrew says that his assessment will take 10 to 15 days. There may be many, so please be patient. Andrew will start the webinar with an overview and then we'll be straight into the questions and answer session. We've already received many questions, so by answering these, it will provide you with practical, everyday situations which you will find easy to relate to. Now, Andrew tells me there are an estimated 450,000 trusts in New Zealand. No one knows for sure how many because there is no national trust register and therefore no official record. So why so many trusts and what were the motivations to have a trust? Essentially, trusts were formed for both practical and emotional reasons. Typical reasons why people formed trusts were, we don't like that chap that our daughter married, so we want her and the grandchildren to inherit our wealth, not him. Another reason, we want to protect our assets against business failure. I want to hide my wealth from any future relationship partner I might fall for. And another one was common at the time, I don't like Michael Cullen raising the top personal tax rate to 39 cents in the dollar, so I'm going to trade through a trust at 33%. Haven't we just heard that again? That Labor will do that as a way of raising taxes. So stand by, something interesting will happen in that area. And FOMO, fear of missing out. If you didn't have a trust, you might be missing out on something. And another common one, I want to be personally poor, so I qualify for a rest home subsidy. Okay, so that's enough from me. So let's introduce Andrew Logan. Andrew is a partner at Mortlock McCormack Law in Christchurch. Andrew has over 30 years experience as a lawyer and a large part of his practice relates to family trusts. Andrew was previously the chair of the property law section of the Law Society and from that position was appointed to the Justice Ministry's Trust Reference Group. That group was established to review the work of the Law Commission, the Trustees Act 1956 and recommendations from the Ministry. This appointment gave Andrew valuable insight into the government's thinking about drivers and the expectations for the law reform. Andrew offers clear and constructive advice to people who have trusts and are uncertain about what to do with them. He has very firm views about the future of trust. So, Andrew, let's introduce you and let's start with some questions so that our audience can get a good overview of what it's all about. So, can you tell us what the new Trust Act 2019 that comes into effect next January 2021, what's it all about, Andrew?
Well, as you've said in your introduction, Jamie, there are a lot of trusts out there, and the law that currently governs trusts, the 1956 Trust Act, is obviously quite old. So the new law is really playing 60 years worth of catch up with trust law and developments in trust law. So the purpose of the new law is to set up the Act to restate and reform trust law. So it's really to play catch up. But it's important to understand that the new law that comes into effect next year is not the end of the catch up, because the law allows the courts to continue to develop the law, and that's will become really important for some of the things we're going to talk about this morning. So the restating and the reform of the trust law is going to be achieved by lifting the standard of trustee performance. So with those number of trusts that have existed for many years, New Zealanders have got basically in some pretty bad habits in terms of running trusts and trust administration. The Act is also going to require a bit of a change of attitude for many New Zealanders who are the trustees of trusts, because it's going to create a new relationship that trustees need to have with beneficiaries. Again, we'll come to this through the talk. It's going to also require people to get back to basics a bit in terms of focusing on really what was the trust set up for, what's its purpose, what's the objects of the trust. I think ultimately, and this certainly came out in terms of the work I was involved in with the Ministry of Justice reference group, I think there is a clear intention to reduce the number of trusts that exist. It's going to drive the numbers of trusts down, because I think when we get into the talk this morning, you're going to see why trusts will be less attractive than they have been.
Okay, so Andrew, what are the main things I need to know about the changes?
Sure. So there's probably two main things that I would say are really important about the new Act. There are new trustee duties and obligations that will affect all trusts, and particularly for trustees, that's going to require, as I've mentioned, the higher standard of trustee performance, and there will be increased risks associated with not getting that right. The second big change is something called the disclosure regime. Now, until now, trusts have been pretty sort of private. The trustees have known what's in the trust and what the trust does, but the beneficiaries generally haven't. So the disclosure regime is going to give, for the very first time, a clear set of rights to beneficiaries about their place in the trust and what they're able to get. So that's going to change, I think, the balance of power that has existed. Traditionally, it's all been in favour of the trustees, and that's certainly going to change in favour of the beneficiaries. The Act's also going to require a much more formal approach to our attitude and our position with trusts. And that formality, again, will come out in some of the things we'll talk about through the talk this morning.
So what about the responsibilities and duties and liabilities now that will fall on trustees? We know they're quite high at the moment. What will change there? If I was a trustee, what do I need to change and know about now?
Sure. So probably the basic way of looking at it is that the trust sets out two sets of duties that trustees have. They're called mandatory duties, and those duties will apply to all trusts, and there will be default duties, and those will be duties that will apply unless your trust says something different. In addition to those duties, which we'll talk about shortly, there are really extensive requirements for record keeping and for trust administration. And that's, I think, going to be a challenge for some people. It's also going to require you as trustees to have a really thorough knowledge of what the trust says, what the trust purposes are, what assets and liabilities the trust has. It's going to require you to have an understanding about the needs and circumstances of all of the people that you have named or have been named as beneficiaries of your trust. And the process for decision making is going to require a lot more thought and evidencing and recording of how that goes.
So the disclosure regime, I read a little bit about that. Can you expand on what the disclosure regime is all about?
Sure. So the disclosure regime is, as I mentioned, it's new. For the first time, this will exist in law. And the purpose of the disclosure regime is to enable beneficiaries to enforce the trust. And what that simply means is that it's going to enable beneficiaries to make sure that trustees are doing what they're meant to be doing. And that is of concern, I suppose, because it's new law. And as I've mentioned, the new Act allows the courts to keep making laws as they decide cases as matters are litigated before the courts. So it's untested, but because the purpose of the Act is all about allowing beneficiaries a much greater visibility about what the trust is doing, that purpose will influence how the courts are going to interpret what that means. So the disclosure regime is in two parts. There is the requirement of all trustees, and this is not an option, this is something you must do, and you'll have to do from next January, is that you must provide basic trust information to every beneficiary that you have mentioned in your trust deed. And basic trust information is simply telling someone, you are a beneficiary of the trust, these are the trustees of the trust, these are the addresses of the trustees of the trust. We'll tell you if there's any change of trustees from time to time. And you have to tell the beneficiaries, and by the way, you have a right to see the trust deed if you'd like it, and any other trust information that you'd like to see. So that's quite a big departure from what the law currently doesn't give beneficiaries. So the basic trust information is there's a duty on trustees to be proactive, so they must do it. It's not a case of waiting for the beneficiaries to come to you. You have to front foot it with them. Other trust information is, again, an area that's going to get tested by the courts, but given the intent of the disclosure regime, other trust information will include not only the trust deed, but it's going to include all the financial statements, bank accounts, bank details, a whole raft of information about what's in the trust and what the trustees have done with it. So the implications for that, I think, are extremely significant. Again, this is new, and I think why it's significant is that disclosure will create an awareness. So it's one thing for trustees, for beneficiaries rather, who may never have known that they were a beneficiary of a trust to suddenly find out that they are. So naturally, they're going to go on a fishing expedition. And I think awareness, in my view, will create an expectation of entitlement. I think the minute you tell someone that they're a beneficiary of a trust, this is what's in the trust, the next question for that, in my mind, is going to be, what's in it for me? And that's where this change of relationship with beneficiaries is going to occur. Now, just adding on to that, the disclosure regime is called a presumptive regime, and what that means in plain English is that you have to provide all this information, or there's a presumption to provide all this information, except if there are reasons not to. Now, the presumption regime is a really complicated and quite difficult thing to interpret, and I think for most mum and dad trustees out there, you simply won't be able to do it without professional help. And what the presumptions are is that if you can find a reason not to, there are basically 13 factors set out in the Act that will tell you if you don't have to. And things like, if I have to disclose that information to my son or daughter, what effect will that have on them? What effect will that have on the other beneficiaries? Is there anything in here that has commercial sensitivity? What was the purpose of that person being a beneficiary? So there's a whole raft of things, but you have to go through, tick those off to say all these reasons apply. Then, having made the decision not to disclose, you then have to go to court and get the court to confirm that your decision as trustees not to disclose was correct. So there's an enormous amount of work, and there's an enormous amount of risk for trustees if they've got that wrong, because if the court have said no, we don't accept that your reasons for not giving the information are valid, that will be all revealed to the beneficiaries, who will find out not only have mum and dad tried to thwart their efforts to get hold of the information and gone to court, and the court's found them wrong. So right. It's really problematic. And the new Act was set up on the basis that trust administration is meant to be cost effective and efficient. This disclosure regime, I think, is really where the legislation will seriously miss the mark in terms of what's intended.
Right. Okay. Now here's an interesting question that's come in from one of our viewers. What happens if I don't do anything to prepare for the 30th of January 2021? Do I have to do anything before then? Can I leave it until after that critical date?
You can absolutely do nothing, but that's probably not a good strategy to adopt, because you'll almost certainly find yourself in breach of the trust, and that will start with the failure to meet the disclosure requirements. That will then probably lead to a failure about trust administration and the administrative requirements. That will lead to the fact that you're making inadequate or improper decisions. And the consequences of all those failures are that there's a risk that you may be removed as a trustee. We are seeing cases in the High Court, one very recent one, where basically unhappy beneficiaries, that's the adult children, sought to have mum and dad removed as a trustee for certain breaches. They were successful, and the court removed mum and dad from the trust. And that's not where you want to be if you are the mum and dad who set up the trust and have put all your hard earned into it.
So it sounds like the beneficiaries are going to have a lot more grunt, a lot more weight of the law behind them, that if they want to challenge how the trust has been managed and operated, the trustees do have to stand up and be counted and be analysed.
That is absolutely the case, and that really is one of the features and one of the focuses of the new Act. The enforcement of the trust, making sure the trustees are doing what they're meant to be doing, is really what is at the heart of this new Act.
Outside authorities, is there any outside authorities that take the initiative, or does the initiative come from within the trust, namely the beneficiaries? Is that the onus is on them to drive the responsible management of the trust, and there's no outside regulatory body that makes that happen?
Well, probably the other way around, Jamie. I'd say that the obligation is on the trustees. I think trustees are on notice now that things are changing. Life as we've known under the old Act is not what life for the new for trust under the new Act is going to be all about. So it's going to affect everyone who has a trust. It will certainly mean there is no business as usual. So trustees should be the people who drive the change. Beneficiaries will hold them to account. There is no register of trusts like the Companies Office or the Land Titles Office. So the external agency, I guess, that ultimately will have the say on this will be the High Court. Because they will be the ones that will deal with the mess when it all goes horribly wrong between the trustees and beneficiaries.
So there's a question here. What is the minimum do you think I need to do? I guess that's a trustee saying that. What's the minimum they need to do?
The minimum you need to do is get your trust deed out and read it. Now, often when I meet clients or deal with people, that's a question I say to them: do you understand your trust deed? One of the mandatory duties that I talked about before was a requirement to read and understand the trust deed. And I think that the fact that that's written into the new Act underscores the generally pretty poor state of New Zealanders' understanding of trust. So what I would say is, get the trust deed out. It might be in a shoebox under your bed. It might be in the filing cabinet at home. It might be at your lawyer's office. Your accountant might have a copy. Get hold of the original signed copy. Don't work off a photocopy that's not signed or dated, because that might not be what you actually need to see. But read it and understand what you've said, and you might be surprised about what you find. Again, I often talk to people who have worked on an assumption that 20 or 30 years ago, when this trust was set up, their lawyer or their accountant told them certain things about the trust, and they've just clung to that, and they haven't ever revisited the trust document. So they might get a surprise about who the beneficiaries are.
Yes.
There are trends as, over the time in terms of sometimes when trusts were set up, there was a very wide beneficiary class that might include you, kids, grandkids, but it might include siblings, it might include spouses, parents, other trust, named charities. Now, all of those people that you have named in your trust deed are beneficiaries. So really read it and understand it. And if you can't understand it, then get some help. The other thing I would say as an absolute minimum is actually read the Trust Act. It's written in for a piece of legislation. It's quite an easy piece to read. I might say that as a lawyer who had some influence in drafting it. But if you Google Trust Act 2019, probably the first thing that will pop up is a site, www.legislation.gov.nz. And that's basically the government's website where every single law, act, regulations, it's all free. You just click on it. And you can read the act. It's quite long, but you will get a sense of what it's about if you just plow your way through it. I would recommend that. I say that to clients too. Next thing to do is a minimum, get some advice. If you can't work the stuff out for yourself, if you're not lawyers, you're not trained in this area, you're not confident in this area, get advice. You probably there will be a lot that you won't be able to do on your own. And I think it's one of those things. I think there's this whole number 8 wire mentality in New Zealand with trust that I can do all this myself. I don't need help. I don't need anyone to tell me what to do. I don't want to pay for it. All of those sorts of things. And I think that's led us to the position where we're in at the moment, where the law needs to change and needs to change dramatically.
Right. Thank you, Andrew. So it's a toss-up between shall I watch Netflix tonight or shall I go online and read this new legislation?
Well, funnily enough, over lockdown, when people were stuck at home and they couldn't go out anywhere, I did get quite a few calls. But a lot of our clients, we'd written to them at the start of the year about these changes, and it was a really good opportunity. You might get bored with Netflix, it might be raining, but it's one of those things. It sounds like a horrible thing to have to do, but it's one of the things you need to do if you want to take this seriously. And believe me, you do need to take this seriously in terms of what's going to happen.
Right. Okay. Now, we've had a lot of people join us since we started. And at the beginning, we talked about the free assessment that you're happy to make with clients. And this will be sent to you via email after this webinar. So you'll have a chance to fill in a form and send it off to Andrew to get some general advice about what you should do about your trust. And the other thing is that we've been asked several hundred times now, are we being recorded? Yes, this webinar is being recorded. And at the end of this webinar, within a few hours, you'll be sent a link to be able to watch the recording. So if you missed the beginning or missed the end or missed it altogether, but you did register, you will receive an email with a link to the assessment request and also to the recording. So back to you, Andrew. Some more questions here. If I don't want to keep the trust, what do I do?
Well, if you don't want to keep the trust, that's good. You've made a decision, but I think it's helpful perhaps to have that decision road tested against some professional advice. If you have engaged a lawyer or an accountant to run the trust because of the nature of the assets that you've got in there, have a talk to them. Know what the trust deed says about winding up the trust. Sometimes, because not all trust deeds are the same, there are probably tens of thousands of different forms of trust deeds out there. So when I talk about trust deeds, I'm talking very generically, but know what it says about winding up or ending of the trust, because there'll be rules in there about how the distribution of trust assets has to work at the end of the trust, but there's quite a bit of a leeway that you might have before the trust ends about that. On the other side of this, it's considering what it means if you have all those assets put back to you personally. So they're out of the trust, they've come back to you. And there may well be relationship property considerations that you want to take into account, either for yourself and your spouse, or in relation to other, say children who might end up with some of those assets. and you're going to need to rethink about your wills and about your powers of attorney. So there's quite a sort of a lot of things to think about winding up the trust.
Right. Here's a good question that's come in. Our trust was formed about 20 years ago. Frankly, I can't remember what assets it owns, and I have no idea where these documents are. What should I do? How do I find them? Who do I ask?
That would be a very good reason for probably not having a trust, if that's sort of the position, and that is a reasonably common sort of scenario. Look, the starting point is going back to your lawyer, trying to remember who you might have used 20 years ago, and people do change lawyers. Not everyone sticks with the same lawyer.
I would all stay with you, Andrew. Would all stay with you.
Look, it might be that if it owns a house, or you think it owns a house, getting a title search for the house and finding through the Land Titles Office, through the assistance of a lawyer, you can find out who did the conveyancing of that house 20 years ago if it put into a trust, and that's probably a good start. If you've had an accountant involved, then obviously going back to the accountant to find out where it is. But yeah, it's hopefully that those sort of things will be the common ways that you can find out where you've got.
Right. Next question. I have a trust that owns the family home that my husband and I still live in. Our children have grown up and left home. I guess we are now empty nesters. Do we really need to change anything?
Well, it comes back to the question: if you're going to keep a trust, it's a bit like getting rid of a trust. You have to have a view about what it is, and if you want to keep the trust, then it's asking the questions of, why do I have this trust? What is it doing for me? Are the reasons that I set up this trust 20 years ago or whatever, are they still valid to my circumstances? And I think work backwards from there. So is it valid for you? Depends why you had it. It depends what those reasons were. I think people tended to forget that when you set up a trust 30 years ago, you had reasons for doing so. All of your circumstances have changed, and you've got to think about a life cycle of the trust, that you've set it up for reasons relevant to you. Are those reasons still valid? And that's probably the basic question. Why do I have this thing? Is it still valid for me?
All right. Here's a very pointed question that's just come in. We have a family trust, and one of our children married a partner who has turned out to be a bit of a liability to everyone in the family. We really don't want them to share in any inheritance. How do we prevent this without a trust?
Without a trust?
Without a trust.
So the relationship property law and the trust law have sort of not worked well together under the old Act. So your main line of defence in terms of this son-in-law that you're not perhaps so fond of is found in the Relationship Property Act and the ability to contract out of that. And what I mean by that, you often hear about people talking about prenups. Well, formally that's known as a Section 21 agreement. And what that's about is regulating between a couple what they expect to be relationship property and what they'd like to see kept as separate property. So that would apply to any potential sons or daughters-in-laws or de facto partners-in-law. But it's equally applicable to trust as well. I think people have, because it used to be a position that trust would act as a ring fence around assets to keep them away from relationship property claims. Over the years, because of the number of trusts, as you imagine, every separation or divorce in the country has involved a trust or two or three in some cases. The law on relationship property has eroded the benefits that trust once offered. So if your primary concern is protecting assets from relationship property, then you need to think in terms of the Property Relationships Act, the old Matrimonial Property Act, not in terms of trusts.
Right.
So hopefully that helps.
Thank you, Andrew. Here's a question from a business owner. My family trust owns shares in 3 companies I own and manage. We did this to protect the company's assets against worst case scenario. Will our trust lose its ability to protect our company assets?
No, there won't be any change. And a very common reason that people set up trust, or why people set up trust, was exactly that. You had assets, or you had a business, and you didn't want to face the personal liability that came with running a business, and that comes from creditors, it comes from WorkSafe, it comes from employees, a whole raft of things as to why you want to keep assets separate. So there'll be no change for anyone who set up a trust for any reason, whether it's asset protection, whatever reason you've set up the trust, nothing changes. But what you need to consider is that everything around you has changed in terms of trustee obligations and the disclosure regime. So it's always going to come down to that balance between it's a trade-off. What do I want to live with in terms of obligation versus risk? And it's interesting when I talk to people about business risk specifically and say, well, can you articulate to me what your risk is? How bad is your risk? And is the trust the only way of dealing with that risk? Are there insurances that you can put in place? Are there better work practices that you can put in place that might reduce some of that risk? You'll never get rid of risk in life, and you'll never get rid of business risk, but you are facing a new regime. So your family circumstances probably need to be considered in terms of the merits of keeping the trust or not keeping the trust for business risk.
Right. Now, you may have covered this earlier on, but it's come up again. Our children often badger us asking what assets we have tucked away in our trust. Does the new legislation mean that we will have to declare everything to our children? I guess that comes back to the disclosure regime.
And the short answer is yes. Absolutely. So one of the consequences of disclosure regime, as I've mentioned, was that expectation. But it's also going to be a window for beneficiaries into the past. What have you done in the past? How have assets been allocated? How have assets been managed? How has assets been lost? What types of things have you done? So if you've got children who have issues with you, or you have issues with them, or their partners or their sons and daughters-in-laws have issues with you, this is where I think this is going to get difficult and uncomfortable. And I think there might be a few Christmases this year, Christmas dinners, which could be decidedly uncomfortable once you embark on telling people what you've done. We don't have to do that till next year, but I'd say start early.
So you think that's a Christmas table discussion? A bit hard to implement things in January when most law firms are away enjoying a hard-earned break, no doubt, Andrew.
After this year, certainly, Jamie. But that's part of, I guess, part of the decision, and I suppose part of the call to arms now is you're going to have to decide fairly soon about whether you retain or whether you wind up. It comes down to that. You want to sort of not just ignore it and put your head in the sand, because it's hard. It's hard to get people to make decisions about trust. It's in my experience, and I think people get stuck about what they should be doing. And I think that the easiest way of trying to break that impasse is to think about, again, why do you have this trust? You put assets, you've worked through your life to build up wealth, to create assets, to create some financial stability for yourself. But by putting them in the trust, you have lost control of them because they're no longer yours. That's the whole point of having a trust, is to separate the ownership. So I think when you're not sure about what to do, think about what your view is on control, because once upon a time under the old regime, you had all the control generally, and that changes once that information about the trust is out and the beneficiary rights are there. So I think if you're stuck, do I keep it? Do I not keep it? Aside from all the other reasons about business risk and tax planning and so forth, think about control, because that's really what it's about. You are generally going to be the only generation who puts stuff into the trust. Every other generation of your family are going to be the people who take stuff out of the trust, and you're going to be obliged to them. on that front. So it's if I can have a simple message, it's about how do you view control? Do you want to control those assets? Do you generally want to control them, or are you generally quite happy that you are removed from them in terms of ownership rights, and you are obliged to everyone else who's a beneficiary in the way that the law requires?
What's the legal age of a beneficiary for you to have to declare the asset of that trust to the beneficiaries? Is it 15? Is it 18? Is it 20? Is there an age?
Well, the bad news is there's no limit. It's not if they're, I mean, as minors, which is until you're 18. If you have minor beneficiaries, that might be grandchildren, might be your own children who are under 18. The disclosure will have to occur onto their guardian, and so that means the parent. So in the case of grandchildren, it's particularly important that you understand and know who your beneficiaries are, because if you have included daughters-in-law and there's been a breakup in the marriage or the relationship, then in theory, if the guardianship sits with of the minor, your grandchild sits with your former daughter-in-law, you'll have to disclose on your former daughter-in-law. So the Act is very, very clear about who disclosure must be made to. It's every beneficiary that you have named. There's not an age limit for that.
Wow, there it is, isn't it? Now, gifting, here's a question about gifting, which has changed, as we know, some years ago. We have a trust and are halfway through our gifting of $27,000 each per annum. I was told that this changed many years ago and that annual gifting is now unlimited. Is this true, and what does it mean to us and the new legislation?
Certainly. So on the 1st of October 2011, the gift duty was abolished. So gift duty, as you will all know with trust, you plugged away at $27,000 a year, $54 per couple, to get rid of the debt associated with the trust. So gift duty no longer applies, but the debt that is created and has been created since October 2011 still needs to be forgiven. A lot of people thought when gift duty was abolished that it automatically wiped the debt that you had with your trust or your trust had with you. That is not the case. And so you need to still get rid of it, but as the question is, it is unlimited. So in theory, you could forgive $1 million tomorrow, all in one fell swoop. There's no consequence in terms of gift duty. There are some other issues that you need to be thinking about, though, in terms of, does that gift have the potential or the effect of defeating any creditors? So if you suddenly want to get rid of that $1 million because you know the creditors are about to knock on the door, you're probably a bit late. And one of the practices we have here that many lawyers adopt is that when you complete gifting of large amounts like that, you also complete a statutory declaration, which is evidence basically to show that you are solvent at the time that you made the gift, that you're not facing creditors, no one's trying to bankrupt you, and so forth.
Okay. Oh, here's an interesting one. Our family trust owns the family home, a batch on Waiheke, a launch, an industrial building which houses my business. There are various finance companies involved, along with the bank mortgage on our industrial building. This would, on the face of it, seem to be quite complex to unwind. Should I bother and pay my lawyer and accountants heaps just because of this new legislation? Do we know the answer to that question? Won't I lose all the protection of my assets that I think I currently have?
Well, the starting point for that is if you've got those range of assets, you can probably afford to get some advice, and I think you should. And I don't mean to be flippant, but it's again, part of the attitude I think we grapple as lawyers with. There's a real reluctance for people to invest in the trust process, to educate themselves and engage. So I think for that question, it goes back to that starting point. Why have you got it? If it's about business risk, reassess where all that risk is. Is it as big or as severe as it was when perhaps you first set up that trust, when you had a lot of risk and not so much wealth? And as you get older, you generally have more wealth and less risk. So There is no sort of right and wrong to the answer about whether you have a trust or not have a trust. And that example it sounds complex. You've got a number of different assets, but it comes back to that simple question. It's you have been the people, perhaps you and your wife have built up those assets. What do you want to do with them? And is the trust the right way for you?
We are newly married. My wife is pregnant, but we have saved enough deposit to buy our first house. We have been told we should form a trust to own our first house. Is this still good advice?
Again, back to the basic question, why do I have this trust, and what are the benefits that will come out of the trust? If you and your wife were employees, you're likely to be employees. Are you not going to own your own business or have that sort of risk? That's quite a big reason that drives trusts. So I'd say, well, probably not for that reason. If it's about inheritance for your young and growing family, that could possibly be a reason that if something happens to you and your wife and your children are little, trust is a really sensible way of holding assets together until they get into adulthood, to provide financial support and so forth. But a lot of people exist without that, and you can create that sort of protection through your will. So trust is a way of doing it, but not the only way of doing it.
Okay, thank you, Andrew. There was a family trust for my children created from their grandmother's estate in 1989. My children's father, who was a trustee, tells them there is nothing left in the trust. How can they find out the truth?
Well, from the 30th of January next year, the truth will be able to be revealed, because you will be able to contact hopefully you know who the lawyer is who administered the trust, or at least go directly to the trustees and say, we have these rights, tell us what's there, tell us what's happened. So this is the cupboard is, or the cupboard doors are swung open and you get to see what's in there. So and again, I'm advising clients that where there is that type of perhaps tension or mistrust, a great way of building some trust between the trustees of the trust and the beneficiaries is to start that process now. It's coming next year. Why wouldn't you start now? It's going to show that you are being proactive, as the law will require you to do. But I think a sort of a measured approach to the trustees now, saying that we know what our rights are, we know what they're going to be next year. Let's start the conversation now.
One of the common questions, trusts were formed so that an individual could be personally poor and qualify for a rest home subsidy. Would that still work? Does it still matter when you apply for a rest home subsidy and you put your hands up and say, I don't own anything, but you've got $1 million house over here?
That, I think, well, certainly it's not as easy as it was. And the abolition of gift duty in 2011, I think, was the precursor to the rest home subsidy regime no longer working when you've got a trust. And exactly that situation where people have tried to make themselves asset poor for the purpose of getting the residential care subsidy has led to the Ministry of Social Development, MSD, who run that scheme, to apply what's called a deprivation test. So they'll look to see, what have you got now and what have you had and what have you done with those assets. And if you've put them into a trust, they can go back and treat you as if those are still in your own personal hands. And that's really what's driven that is, I guess, a social policy that previous governments have had around the affordability of the residential care scheme. And on the basis that, if you've got assets to pay for your retirement care, then the taxpayer shouldn't be asked to do that. And it's that simple. And we've got an aging population, a shrinking taxpayer base. I don't think any government of any colour or shade is going to go back to that regime. MSD, it's quite a tricky area, and it's quite hard to be absolute about. But the theme, or the thrust, if you like, is this deprivation test, and that's what you need to keep in mind. You certainly wouldn't. I would never recommend anyone now to set up a trust for that purpose. It's the ship sailed on that one.
Right. Here's a simple question: do you feel that a trust still offers protection from future partners?
Increasingly, no, is the short answer to that, and that's because, again, one of the drivers or reasons for the reform that we're facing with the new Trust Act has been the way that trust law has collided with relationship property law. And the objects of the Property Relationships Act, the old Matrimonial Property Act, was to provide this nice, neat, simple 50-50 division of assets and liabilities when couples separated. So when you had a trust that sort of sat in a couple's life, and it held the house, the batch, the farm, whatever it held, that the social objective of the Property Relationships Act was frustrated. So what we've seen over the years, and particularly in the last 15 years, is a real move by family lawyers and the family courts and the High Court to find ways of trust busting. And so that the fact that an asset sat in a trust no longer is a guarantee that it's beyond the reach of a relationship property claim. And the Property Relationships Act has been reformed over the years to provide a number of mechanisms where claims can be made against trust assets and to be treated as if they were still personal assets. So I go back to what I mentioned before. If you are looking to use a trust for keeping assets away from your partner, the trust is probably, for that reason, is not the right vehicle. The right vehicle is a Section 21 agreement or a contracting out agreement with that partner. That's particularly relevant for, say, second time round relationships or marriages.
Why must I now provide financial records for the trust to my lawyer? Why must the beneficiary be given our financial information? I think you've sort of covered this, but there's an angle to that.
Yeah, well, it does come under that part of the Trust Act, under the disclosure regime, under the subheading of trust information. So it goes back to the more basic question of why, which is the enforceability of the trust against by the beneficiaries against the trustees. And part of that will be, what does the trust have in it? Because if you think about it, if a trust has been set up by someone and you're named as a beneficiary, it's a bit odd that you don't know, A, that you're a beneficiary, and that you're not aware of what the trust has. Because the whole point of it being a trust is that you don't own the assets. They are not your personal assets. You are holding them on behalf of all of the people that are the beneficiaries. So it's not your information per se. It is information that the beneficiary is entitled to have. So that's hopefully the simple answer to that question.
Right. So what's the process for going through to extract assets from a trust? If on review it seems that the trust has done its dash, or it's become redundant, or it's past its use by date, and you've got assets in that trust, what's the process for extracting those assets? And who takes ownership of those assets, no matter what they are? I mean, maybe just start, for this example, with the family home, and then there might be some investment assets and so on. But how do they get extracted from the trust? Who takes ownership of them? And if there was a family home, is there conveyancing involved? Is there a cost to reconveyance the house from the ownership of the trust or the trustees back into someone else's name? And if there's a finance on the property, a mortgage or whatever, how does the bank handle that? So that's quite a complex question, but I guess you've got a trust, you come along, or the trustees come along and say, right, time's up, let's unwind this trust. How does that process happen, and what are all the sort of costs and implications along the way, Andrew?
Sure. So what you're really talking about is if you want to wind up the trust, or even if you don't want to wind up the trust, but you want to get rid of some of the assets out of it that you've once upon a time put in. So let's say the family home. So first thing you need to do is look at your trust deed to know that you can distribute what's called capital, because that's what the house would be. You would decide as trustees that you no longer wanted the trust to own the house, and you wanted to distribute that trust back to mum and dad as the beneficiaries. So you'd create a resolution to that effect. You'd have a deed of distribution, and that would then need to be accompanied by the legal change of ownership, because the house at that point is owned by the trustees on behalf of the beneficiaries. You're going to distribute it to the beneficiaries, being the mum and dad beneficiaries. So that requires a change of ownership in the Land Titles Office. So the title for the house is updated. As you mentioned, if there's a mortgage in place, you will need to get the bank to discharge that mortgage and create a new mortgage over the house that is owned by mum and dad. Mum and dad would need to consider how they want to own that property, whether they own it as joint tenants or tenants in common. So there's a bit of work to work through, but it's the consequence of having a trust. You can't expect to do all this with a click of a finger and not expect there to be some paperwork and engagement with lawyers. That's how we make our money, I guess, in that process. And then once the house is back in your own name, again, you've got to think about what does your will say about your assets, because suddenly you've got a more valuable asset in your estate that's governed by your will. Hopefully that covered all the points, Jamie.
Yes, there's some complexities coming, isn't there? Is it possible to set up a trust so both of our children will get a regular proportion of our estate over the next 35 years?
Yes, it would be. I mentioned about one of the intentions of the new Act, and it's about focusing on really the purpose and the intent of the trust. If you're very clear that that's your purpose about setting up a trust and that's the reasons why, then entirely valid. The beneficiaries will be made, your children will be made aware of what's in the trust and the fact that it's intended that we are not going to give everything to you at once. You are going to get it over time, either income or capital distributions in accordance with a formula or whatever you put in the trust deed. I mean, you can do that through your will. Your will would be just as effective, and given the 35-year horizon that you've got on this thing, you're going to need to be thinking about who are the people, whether it's through my will or whether it's through my trust, who are the people that are going to be there to administer and make all those decisions, and if there are any discretions they've got in the process. But absolutely doable.
Now, the current law gives the age of a trust as 80 years. Now, I understand it's gone out now for new trusts from January next year onto, was it 120?
125.
125. So why the jump from 80 to 125? Because although we're all living longer, some of us will see out 80 years with a bit of luck, but I don't think there's many watchers today that are going to get to 125. So why the jump from 80 to 125 years?
Well, it was actually originally mooted to be 150 years. So 125 years. Why? It's to recognise that New Zealanders are living longer. Back in 1956, we probably didn't live as long. As each generation is living longer than the one before it, the concept of having a trust that can last for you, your children, your great-grandchildren, possibly great-great-grandchildren, that's sort of the rationale for pushing that out to 125 years. And in doing so, we abolished something called the Perpetuities Act, which I won't even get into. It's a very complicated legal thing. But it's, I guess it provides a bit more flexibility about the lifetime of the trust. But I think what I find in practice, though, is that most people have set up a trust for them, for their for circumstances like credit protection from business risk or whatever. It's nothing to do with trying to provide a sort of an intergenerational entity that goes on for the next 3 or 4 generations of your family. So I don't know in reality that there's much to be gained or much advantage, because many people, particularly the mum and dad people, will say, look, after I've died or the death of the survivor of us, look to wind up this trust. There's probably limited value in carrying it forward, for our unknown grandchildren or great-grandchildren or great-great-grandchildren.
We spend all our life trying to earn enough to accumulate assets, and then the biggest problem is how to get rid of them all. So that's just an aside. Look, Andrew, we're up to 54, 55 minutes. We're expecting to have Q&A for about 45 minutes here. And there are dozens and dozens and dozens of questions just rolling in on the screen here that we are not going to get anywhere near today. So I think we need to wrap it up. For all those who have joined us since the beginning, or not since the beginning, there's two things to share with you, is that this is recorded, and in a few hours' time, you will receive an email with a link to be able to watch the recording at your leisure. So it's either Netflix or us, but I know you'll choose Netflix. It's probably important that you do watch this if you have a trust in the family. And Andrew has also offered to do a free assessment, a high-level overview of your trust situation. If you complete a form, when we send out the email, a link to that assessment questionnaire will be in that email. Andrew, so maybe to sum up, with your free assessment request form, what are you going to get back to those people? What are you offering, and will it be detailed or once over lightly? Just explain what you're offering to do.
Sure. So the purpose of that free assessment is really just, it would give me an idea, I guess, in terms of your understanding and knowledge of the trust, because I think some of the questions are directly aimed at getting that information out of you. That will help me understand where you sit with your trust in terms of your knowledge and your confidence to be able to answer the questions. What I would then aim to do is speak to you. If you're in Christchurch, happy to meet with you by Zoom. Lots of us are used to that now, or by phone. It will be high level. Obviously, having not met you, I don't have a lot of the background or the insight, but it's more just perhaps to give you my view about your particular circumstances, because again, there's not a right and wrong to this, or a yes and no. It's about you, your family, and what you're really trying to achieve. And I think we can have that discussion relatively briefly. That might help form, as I mentioned earlier, just forming a view about what you want to do next. So the goal of perhaps the free assessment is, it's certainly not going to answer all of your questions and give you an absolute outcome, but I think I've been doing this long enough, and I've got a reasonably intuitive feel for where people sit and really where people are comfortable. And for many people, it might be the first time you've actually really had to think about this stuff, and or you've had some disquiet about the trust, and it isn't for you. So that's hopefully what we can achieve. Once I've seen the information, we can have a discussion, and I can say to you what I think what you should be thinking about to do next. And it will come down to basically, I'm going to keep this trust, or I'm going to wind it up.
Thank you, Andrew. Because of the large number of questions that, as I say, I keep rolling in, we're going to try and collate those questions and send out an email with as wide a range of answers as we can possibly do that. Some will be individual, because some of you have shared confidential, private information that you've asked to be kept anonymous, and there's some very searching questions that have been lodged for Andrew to have a look at. So we'll give those some personal attention. They will not be broadcast and not be used in any other webinar. They'll be kept confidential between yourself and Andrew, but we will try and collate the main thrust of the questions. So we'll wrap up very soon. Andrew, maybe just spend 3 or 4 minutes giving the big takeaway, having listened to you. What are the key things, if we are a trustee or a beneficiary, what are the key things we need to take out of what you've just been talking about for the last hour?
Sure. Probably the main thing is change is coming, and the change is significant. So as I mentioned before, life for trust under the old Act is certainly not what the new trust is about. So it comes back to those basic questions. Why do I have a trust? Are the reasons still valid? and do I have the appetite to embrace the new? And that's going to be a challenge if for people who've had 30 years of it's my trust, I'll do what I like. This is going to be confronting for you. So an acceptance of change is really important, and a willingness to accept that change. So going back to the why do I have a trust? That's really the critical and careful assessment and consideration that you'll need to make. And I suggest you probably can't get there yourself. It will involve a discussion with your lawyer and accountant. I'm not saying lawyers have got the answers either. It's often a collaboration that we have with our accounting colleagues around what's best for the client. What you do next is about what's best for you. Ignore basically everyone else in the sense that don't worry about the other beneficiaries. Don't feel obliged to the other beneficiaries, because if you're the people that have put the assets into a trust, think about you and think about what's next. If you are keeping a trust for the next generation, think about what that looks like and how that's going to work, how a trust is actually going to work practically for your adult children or grandchildren. As I've mentioned, there's no right and wrong about having a trust or not having a trust. Jamie mentioned in his intro about the FOMO, the fear of missing out, and the sort of the social credibility people had when they could sort of say that they had a trust. We're much more sophisticated than that now. We're much more down the track than that. So think of it in terms of you. Think about what's best for you. That's probably the main thing I would emphasise and do emphasise to clients.
Right, Andrew. Look, you've given some valuable time and a massive amount of very simple but helpful information. I think there's going to be a lot of households to be talking about this over the next few months, and that family disputes don't arise, because the intention of the legislation is obviously for the better, not for the worse. But as trustees, we need to understand what it's all about and do the very best that we can for our beneficiaries. So thank you again for your time, Andrew, and I'm sure you're going to get a lot of requests to help with some assessments. So if you're going to be one of those that send in the form, please be patient. I'm sure Andrew's going to have many weeks' work ahead of him. Thank you, Andrew, for your time, and thank you for joining us for this webinar. It's been a very enlightening hour or so. Thank you for joining us.
Thank you.